Welcome to your first key concept lecture for criminal law. A few housekeeping thoughts before we start the substantive material. My name is Casey Corey. I will be your key concepts lecturer for this course. I was a state prosecutor in Miami for 10 years. I am excited to talk introductory criminal law concepts with you. By the end of this course, you will have an understanding how the American criminal justice system operates, the types of behavior that is criminalized, and defenses to those crimes. If you don't already, you'll learn how to read a legal case and how to apply these concepts to the real world. Please note that your instructor of record for the semester may be different. Each module in this course has a key concepts lecture just like this one. We will tackle the big ideas or concepts from the readings, but these lectures are not meant to cover everything that is testable from the module. You must do the readings and you must take good notes on the readings. There is a learning curve to reading and processing case law, so if you haven't read case law before, then give yourself extra time to get through the readings. This course is also going to ask you to think and apply the concepts that you're learning. You may encounter some assignments that won't have a clear answer in the readings, so you'll be asked to think and process the information that you were given and apply it in those assignments. So make sure you've given yourself ample time to think as necessary. All right, let's dig into the substantive material for Module 1. In this module, we're going to go over the basic goals and sources of criminal law in the United States. To start, there are two basic types of law in the United States, civil and criminal law. If you've taken a previous law course, such as Introduction to Constitutional Law, then that was likely civil law. In civil law, the focus is on reparations. How can the person suing be remedied or made whole? The answer is usually money, and how much money is often debated. In criminal law, the focus is on punishment. Once someone is found to have committed a crime, the focus will turn to the person's punishment. As the reading mentions, the same set of facts can give rise to both a civil and criminal case. For example, say there's a fatal incident in the parking lot at McDonald's. There's a history of crime in the area, and McDonald's has done nothing to make the parking lot safer for its employees, its customers, or its consumers. The lights in the parking lot are all broken, and there are usually a number of people with criminal backgrounds loitering in or near the parking lot. One tragic evening, a customer leaves the establishment. One of the loiterers approaches the customer asking for money. An argument ensues, and the loiterer hits the customer in the head with a glass bottle. The customer is ultimately okay, and the wounds required stitches. The loiterer is charged in criminal court with aggravated battery. The victim sues McDonald's in civil court for its failure to take action to make the parking lot safer. In addition to suing McDonald's, the victim could also sue the loiterer in civil court as well. Practically speaking, though, the decision may depend on whether the loiterer has any money. There's not much point in spending a whole lot of money to mount a civil lawsuit if there is no way to be made whole at the end of the lawsuit. Because criminal law focuses on punishment, it doesn't matter whether the defendant has money, since that's not the goal. The victim from the McDonald's example also doesn't get to decide whether criminal charges are brought. That's the government's decision. We will talk more in depth about how charges are brought in the next module. There are several different types of goals for criminal punishment. There's rehabilitation, restraint, retribution, deterrence, and restorative justice. You may also find instances of restitution being ordered as part of the criminal sentence or plea deal. And again, restitution is money. The rehabilitation goal is when the sentence includes some sort or form of rehabilitation, such as a sobriety program for a repeat drug offender, an anger management program for an offender who has trouble controlling his or her temper. The idea is that if we can equip the offender with the right tools that are taught in these programs, then they will be less likely to commit another offense. There's also a restraint goal, and I think this one is fairly obvious. The goal is to remove the offender from the community so that the offender will not commit another crime. For this, we can think of prison, jail, and home confinement as part of the sentence. We will discuss these forms of restraint in more detail in the sentencing module. For now, It's sufficient that we understand that the restraint or the removal of the offender from the community is an attempt to keep the community safer. There's also a retribution goal, and this goal is the most controversial. It's the idea that an offender deserves to be punished, even if the punishment doesn't actually rehabilitate or deter future crime, just being punished for the sake of your actions. The deterrence goal works to stop crime both on the individual and societal level. If you know there's a punishment for a certain act, then you won't commit the act in the first place. So that would work both for you, the person who wants to commit the crime, and for you as a you all in society in general. The reading also mentions restorative justice goal, the idea that the victim and community also need to heal. Oftentimes, this includes restitution. So, if the defendant stole $10,000, the defendant may be ordered to pay the money back. It can also include community service and allowing the victim the opportunity to give a statement during the sentencing, or maybe the defendant could be ordered to do things like write an apology letter to the victim as part of the sentence. But the goal is ultimately to help the victim and the community heal after the crime has been committed. All of these goals are criticized and have their limitations. Mostly the academics and critics look at whether they work and to what extent does the punishment actually achieve these goals. Deterrence, for example, requires a potential offender to engage in a cost benefit analysis before committing the crime. The analysis might consist of questions like: do the costs of being punished outweigh the benefits? What's the likelihood of getting caught? Does the offender even know the possible punishment, though? And is there even time for the offender to think about these actions before committing the crime? The Banks reading does a great job highlighting the limitations of these theories. The reading also mentions the just desserts theory, which more or less lead to sentencing guidelines for judges so that there wasn't as much disparity among sentences for the same crimes. These guidelines exist on both the federal and state levels, and the guidelines are very simply a mathematical calculation that the legislature created. We will discuss the sentencing guidelines in way more detail in the next module. That was a lot of theory. So let's talk about how these goals of punishment might be served with a real world example. Hello, Martha Stewart. In 2001, Martha was on a plane with a close friend when she called her office to check for messages. There was a message from her broker. He recommended selling her shares in a pharmaceutical company called InClone Systems. This recommendation was made just short of a public announcement from the company that the company did not pass FDA approval. Martha claims to have had an order in place with her broker to sell the stocks if they dipped below $60 a share, which was happening when the broker left the message. But among many other things, the actual existence of this order was disputed. She was charged in federal court with 9 various counts of insider trading and failure to cooperate with authorities. Ultimately, she was found guilty on 4 counts of federal crimes, including guilty of conspiracy, obstruction of justice, and making false statements to federal investigators. The trial court sentenced Martha to 5 months of jail, followed by 2 years of probation. The first 5 months of probation were to be home confinement, meaning that she couldn't leave her 153-acre property for those first 5 months. She was ordered to wear an electronic monitoring bracelet. These bracelets are usually used so that the authorities can ensure that an offender is actually staying on their property. And as a practical matter, though, judges do usually let a defendant leave their house for a medical issue or another issue that's approved in advance by the judge or the probation officer. So what kind of goals of criminal punishment did this sentence actually serve? Did it serve the rehabilitation goal? Well, there are no kinds of programs ordered, nor were there likely any that could be ordered. Martha was mostly convicted of not cooperating with authorities, so there weren't many tools the government could teach her in a program that would prevent this kind of crime in the future. It wasn't like a drug rehabilitation program or an anger management program. So So the sentence probably didn't serve the rehabilitation goal here. Do we think it served the restraint goal? Well, she was physically restrained while in jail and on home confinement. She probably also wasn't allowed to travel after home confinement, but while she was still on probation, she probably had to check in with the probation officer and follow the other rules that probation requires. So, in a way, she was restrained for the entire sentence. But the type of crime that she committed, of committing conspiracy and lying to the authorities, she didn't go anywhere to commit those crimes in the first place. It wasn't like she went to the store to commit a robbery. So, confining her, or the act of removing the offender from the community, didn't really prevent her from committing new crimes, so to speak. So, I'm not sure that the sentence really achieved the restraint goal. Then we have the retribution goal, which I do think that was pretty obviously accomplished here. She was punished for her acts. She was found guilty of those crimes and was given a sentence. Did the sentence fit the crime, though? A number of critics think the government acted too harshly in this circumstance. Did this sentence serve the deterrence goal? Well, on an individual level, not really. Martha continued to outwardly maintain her innocence. Though we of course can't know how the case impacted her on an individual level, but maybe it did serve the deterrence goal on a general level for the general community or the general public. A federal prosecutor was quoted in response to the critics that the government was too harsh on Martha as saying, "It is an accepted principle of prosecution to use celebrated cases this way. There's nothing improper in the general deterrent effect," he says. But it would be hard to measure whether it really is having an effect on the general public. And finally, for the restorative justice goal, I don't think there's any accomplishment of that goal here. There was no true victim for the crime, and Martha was never ordered to participate in community service or anything of the like. So now that we've gone over the basic goals of criminal law, we need to ask, what laws actually are the basis of criminal law? Well, three sources mostly. We have the common law, and federal and state law. I also put constitutional law, but that kind of fits in the things that we'll talk about in a moment. But federal and state law can be combined to a general um, category of legislative law. But let's start with the common law. What is common law? Well, early English customs differentiated between felonies and misdemeanors. We have the same classification now, and the difference between the felony and misdemeanor crimes, practically speaking, is how severe the punishment is. For a felony crime, you can receive a larger sentence or a longer sentence, say you can for a misdemeanor crime. But in early English law, the common law also defined the crimes. Today, every state except Louisiana, which is based on a French civil code, adopts the common law as the law of the state, except where statute provides otherwise. And most states have indeed codified all of their crimes. Though, as you'll see as we go throughout this course, even when the crime has been codified, the judges will also often look to the common law to help define the terms that the legislature has used in the statutes. So then we'll also look at legislative law. The federal and state legislatures codified their crimes with the required elements. And judges still have a critical role here interpreting these statutes and regulations. And as you'll see in a couple of the cases, they can get pretty lost in the weeds of interpreting these statutes. And we'll also talk about the Model Penal Code. What is the Model Penal Code? Well, as the states and federal governments codified their own crimes, criminal law in this country was incredibly diverse. So in 1962, a group of lawyers, judges, and scholars from the American Legal Institute created the Model Penal Code. And states that have adopted the Model Penal Code have all adopted it with their own variations. So no one's adopted the Model Penal Code exactly as written, and it is just a model of the crimes written out with elements. And you'll see we discuss the Model Penal Code for almost every crime that we talk about in this course. And when we do talk about the Model Penal Code, we'll be talking about it in reference to how the American Legal Institute defined the crimes and not how a particular state defined the crimes. But your text will also do a great job of pointing out how the model penal code might be different from a state that adopted something very similar. That might not make sense right now, but you'll see it at play as we go through the cases. And throughout this course, again, we will look at all three of these: the common law, legislative law, and the model penal code. Most of the statutory laws will be discussed in context to a case from our readings, but most of the statutes that we are looking at, even if it is specific to a state such as California, other states usually have something very similar. And we will all articulate the relevant parts of criminal law as it existed in the common law, because I said common law is still often referenced in how we interpret these statutes. And then, of course, we will compare it with what the model penal code says. And a note on the constitutional law: the U.S. Constitution didn't actually codify any specific crimes per se. Like it didn't codify burglary or arson or murder, though it does provide some guidance in terms of criminal procedure with the Fourth and Fifth Amendments. Most Supreme Court cases are reviewing a federal regulation, though some of them touch on the constitutional constraints. We won't go very far in depth, if at all, in constitutional law in this course. There are other great courses that Doral College offers that will really jump more into the Fourth and Fifth Amendments and the other constitutional limitations on statutes. So, for your study guide for this module, as you're preparing for the quiz, you're going to want to understand what makes criminal law different from civil law. You're going to want to understand and be able to apply the 5 goals of criminal law as we discussed in this lecture. And you're going to want to be familiar with the Martha Stewart sentence and how that served the goals of criminal law. And you're also going to want to know and understand what the sources of criminal law are in America. Again, you aren't responsible for an in-depth knowledge of the sources of criminal law, but just that there are 3 kind of basic ones that we're going to look at and where we get criminal laws from. And I'm looking forward to embarking on this adventure with you.